Mr. Blunt.
Thank you, Chair. Mr. Gore, Professor Mueller, and Professor Bauer, you all, in each of your testimonies, you highlighted the importance of that the bill had in clarifying that states must use laws enacted before Election Day. Let me put two or three thoughts out there, and you can all three respond to this. What potential problems would that provision solve? How does that provision help maintain the integrity of the elections? And does the provision still uphold the rights of states to actually craft their own laws regarding elections? And let's just start with Mr. Gore here right in front of me. We'll go Mr. Gore, Mr. Mueller, and Mr. Bauer.
Thank you, Senator Blunt. That is a key provision of the Reform Act because it leaves the people and the people's representatives in the state legislature in charge of prescribing the rules for presidential elections as the Constitution directs. It would prevent efforts to change the rules of the election after the game has been played. It is a fundamental premise of our elections that they are held in a free and fair manner under rules that are set in advance, followed during the election, and are not changed after the election. And so the Reform Act is a key provision that would prevent efforts to change the rules after votes have been cast, counted, and compiled. It would leave state legislatures in charge of setting those rules as the Constitution directs, and would ultimately empower state legislatures to set those rules in the manner that they deemed best in each individual state.
Okay, Mr. Mueller.
Thank you. So that provision works well in tandem with abolishing the failed to make a choice provision. And the goal is that there's one election day, the first Tuesday after the first Monday in November. All the rules are going to be in place then, and we're going to follow those rules and adhere to them. And there were some concerns that arose in 2020 that legislatures could show up in December or January and appoint a slate of electors under rules that didn't exist at the time. There was a little conversation about this in Florida in 2000. Louisiana in 1960. This was a problem in 1876 as well. So making sure that we have stable rules up front, that we know we're having a popular election, and all of those rules are going to control and govern the recount and other processes that happen after Election Day is crucial to ensure that the votes and the voices of the people will be represented when that certificate gets to Congress.
And Mr. Bauer.
I completely associate with the comments just made by Mr. Gore and Professor Mueller. I think that this is a crucial part of Electoral Count Act reform and well reflected in the Electoral Count Reform Act. The Congress fixes the date under the Constitution of the election. Due process requires that congressional authority be respected, and that state legislatures do not attempt after the fact, once the results are known, to change the rules that were in place and on which the voters relied. And so it is essential for that reason within our constitutional framework and for the additional points that were made by Mr. Gore and Professor Mueller.
Thank you. Ambassador Eisen, does anything in the bipartisan proposal displace any of the existing federal or state claims that are available? Now, it does seem like there are plenty of places to go to court, and as others have pointed out, to challenge problems that are perceived or real immediately after the election day itself. Is there anything that prevents all of those options from continuing to be available?
Senator, the options do remain available. I will note, and I'm going to the place in the bill, that at the end of the 6-day period, in order that the certificate have binding effect here in Congress, that the subsequent state or federal judicial relief, this is in 5C1, has the effect of, in order for that to have effect, it will cut off the state review. So we are establishing a cutoff here, and I know there is some concern by those who actually have to administer this, that with the length of that period. So that is why we would like to have more time in order that state and federal procedures can run their course.
Mr. Gore, do you think more time is a helpful thing where you have all of these current remedies in law?
I don't believe that more time is necessary to allow the courts to adjudicate any disputes in presidential elections in the future for several reasons. First, the Reform Act preserves all of the existing state procedures for adjudicating those disputes. So the federal claim or the federal suit would be filed in most cases, if not all cases, after a state process already has played out. Second, it's going to be a very unlikely case that would be resolved within only 6 days. Most states certify the results of their elections well before that 6-day period would begin. So for example, in 2020, Delaware certified its election results on November 18th, nearly a full month before the Electoral College convened. Third, the issues presented in any kind of federal suit would be very narrow. The issue would only be whether the governor had failed to certify the correct slate of electors as required by state law in existence prior to Election Day. And fourth, as I think Mr. Bauer may have mentioned before, the states have proven, and the courts have proven very adept at adjudicating these disputes in a very quick manner. And that includes not just state courts that deal with election contests and challenges, but also federal courts, including the U.S. Supreme Court, which in many cases has resolved election disputes very, very quickly.
Thank you. Thank you, Chairman. I may have other
another
questions
one?
later or
Okay.
for the
Yeah,
record,
we'll
but
do
we've
some-
got a number of members here. Let's go
Yeah,
move
we
on.
can do some later, Senator.